Good morning, everyone. It is my pleasure to reconvene the 19th meeting of the Joint Select Committee on Human Rights, Equality, and Diversity. This public hearing is being broadcast on Parliament Channel 11, Parliament Radio 105.5 FM, and the Parliament's YouTube channel, ParlView. I would like to welcome with us the officials of the Trinidad and Tobago Police Service, as well as the Police Complaints Authority. My name is Nian Gatsudoli, and I'm the chairman of this committee. And at this time, I would like to invite the members of the committee to introduce themselves, starting with our vice chairman.
Good morning, everyone. Glenda Jennings-Smith.
Good morning, everyone. Esmond Ford, member of the committee.
A pleasant good morning to all of you. I'm Vidya Gaidin Gopi Singh, member.
Good morning, Saddam Hussein, member.
Good morning, Dennis Moses, member.
Thank you. Now that we have introduced ourselves, I'd like to invite the officials from the police service as well as the Police Complaints Authority to introduce themselves, starting with the police service.
Good morning, Chairman and members. Stephen Williams, Acting Commissioner of Police.
Good morning, Devda Dulalchan, Acting Deputy Commissioner of Police.
Good morning, Garfield Moore, Acting Assistant Commissioner of Police, Tobago.
Morning, everyone. Hari Krishnan Baldev, Assistant Commissioner of Police, Acting South.
Good morning, everyone. Beverly Lewis, Assistant Commissioner Northwest, acting for Port of Spain and Western Divisions.
Good morning, everyone. Name is MacDonald Jacob, the Assistant Commissioner for the Northern and Eastern District.
Pleasant good morning, everybody. I am Patsy Joseph, Assistant Commissioner of Police, acting for the region of Central Northeastern Divisions.
Good morning. My name is Erwin Hackshaw. I'm Assistant Commissioner responsible for anti-crime operations. Thank you.
Good morning, Chairman. I am David West, Director of the Police Complaints Authority.
Good morning, Madam Chairman and members of the committee. I am Michelle Solomon-Baksh, Deputy Director of the Police Complaints Authority.
Good morning, Madam Chair and members. I am Alan Miguel, Head of Investigation at the Police Complaints Authority.
Good morning, Anita Mangra, Team Lead Legal Counsel, Police Complaints Authority.
Thank you, and it's a pleasure having all of you with us this morning. This committee recently inquired into the human rights of remandees at our nation's prisons regarding the fact that they are unconvicted and therefore deserving of certain amenities and considerations. However, recognizing that in order to arrive at the remand yard, the remandees and many others would have first been detained at various police stations, the committee set about to take one step back to determine the circumstances of detainees at police station holding cells. In 2016, a U.S. country report on Trinidad and Tobago highlighted treatment of detainees as a serious human rights issue. In 2017, a Facebook Live video from inside a holding cell showing less than ideal conditions went viral. In 2017, a man hung himself in a police holding cell in St. Joseph. Also, as of 2017, only 2 stations were reportedly configured to be able to house juvenile detainees separate from adults, according to the regulations of the Children's Act. In view of these incidents and our international obligations under the UN, the committee set ourselves the following objectives. 1, to determine the Trinidad and Tobago Police Service's compliance to legislation with respect to detainees at police stations in Trinidad and Tobago. And 2, to examine the physical conditions of holding cells at police stations. We received 5 written submissions, and we are grateful for that, from the Trinidad and Tobago Police Service, the Police Complaints Authority, the Office of the Ombudsman, the Trinidad and Tobago Police Service Social and Welfare Association, and the Equal Opportunity Commission. Viewers and listeners who are looking at the program or listening today can send the committee questions related to today's topic via email at parl101@ttparliament.org, on Facebook at ttparliament, and on Twitter at ttparliament. At this time, I'd like to invite brief opening remarks from the Commissioner of Police Acting, Mr. Stephen Williams, as well as Mr. David West, Director of the Police Complaints Authority, in that order.
Chairman and members, good morning. Thank you very much for the invitation. We would have submitted what we consider almost a comprehensive account of matters relating to detention at police stations. However, there are some minor corrections that we would want to advance during the course of this session for information which may be a bit erroneous or missing information. But just to say, we are available to furnish the committee with all the relevant answers to the questions that may arise this morning. Thank you very much.
Thank you. Mr. West.
Morning again. Honourable Chair, members of the Joint Select Committee on Human Rights, Equality and Diversity, permit me to introduce the representatives of the Police Complaints Authority who have accompanied me to assist this committee in its examination of the treatment of detainees and conditions at holding cells. It is our collective view that these issues are of paramount importance, not only to this jurisdiction, but also internationally. As said before, to my right is the Deputy Director, Ms. Michelle Solomon-Baksh. To her right is the Head of Investigations, Mr. Alan Miguel, and further to his right is Team Lead Anita Mangra. We stand ready to clarify matters disclosed in our previously furnished written response to this committee's questions, and to further assist this committee to the extent that our capacity and statutory obligations of confidentiality under Section 21(4) of the Police Complaints Authority Act shall permit. At this juncture, I crave your indulgence as I place in context the PCA's role as it relates to the issues of the treatment of detainees and the conditions of holding cells in Trinidad and Tobago. The PCA is an independent corporate body established pursuant to the Police Complaints Authority Act, Chapter 1505, as a long title of which outlines the nature of matters over which the PCA has jurisdiction to exercise its functions under Section 21(1) and powers under Section 22(2) of the Police Complaints Authority Act, namely criminal offences involving police officers, police corruption, and serious police misconduct. The term serious police misconduct has been designated under Section 4 of the Police Complaints Authority Act, and I quote, the commission of a disciplinary offence under the police service regulations which the authority considers to be so serious as to bring the police service into disrepute, close quotations. Over the past 7 odd years of operation, the PCA has received reports concerning, among other things, allegations of criminality and serious police misconduct originating from assaults, deaths whilst in police custody, and other forms of violence, excessive use of force, and abuse meted out to citizens by police officers. While the PCA has consistently adhered to its obligation under Section 29 of the Police Complaints Authority Act to ensure the maintenance of a permanent record of every complaint, we have historically categorized our complaints according to the alleged offense committed. We have not, however, further subcategorized them so as to capture specifics on whether the alleged offense occurred whilst the alleged victim was detained in a holding cell. By way of example, if a person reports to us that they were beaten by Officer X while detained at, for example, the St. Joseph Police Station, our current record-keeping system does not trigger us to input information regarding where the alleged beating occurred, save and except for the police station at which the incident took place. Therefore, while the information concerning detention and the attending conditions may appear in individual complaints recorded by the PCA, the retrieval of such information is considerably time-consuming, as our electronic searches are limited to preordained categories which, at this time, do not include specifics on whether alleged acts of criminality or serious police misconduct occurred whilst the person was detained in a holding cell. In this regard, we are grateful that the committee's exercise has prompted us to reconsider our scope of record-keeping categories, particularly as we recognize that the PCA has a crucial, though arguably indirect, role to play in ensuring that the inalienable human rights of the citizenry are respected, even in conditions of detention. In this connection, it is useful to state that once we have concluded investigations into incidents of abuse which alleged occurred whilst a complainant was detained, we are in a position not only to recommend prosecution to the DPP where the evidence supports a criminal charge, but also to recommend to the institution of disciplinary proceedings in respect of the alleged defaulting officer. If the receiving office holder decides to act on the recommendation made, the alleged defaulting officer would be called upon to answer the charges laid against him in respect of treatment allegedly meted out to the complainant whilst in the officer's custody and care. While we understand that a police officer in the execution of his duties may have cause, perhaps in unpredictable circumstances, to make a judgment call on whether or not to use force to protect himself or others, or to overcome resistance, or to effect some other lawful objective, we are equally cognizant of the fact that a detainee has rights which cannot be trampled, especially given the unconvicted status of such individuals who may simply be awaiting charge, detained on inquiries, or have been charged or are awaiting bail at the next available opportunity. The PCA is also mindful of the fact that Trinidad and Tobago has been a member of the United Nations since September 18, 1962, and all member states are members of the General Assembly. On December 9, 1988, the General Assembly, at its 43rd session, passed a resolution concerning a, and I quote, body of principles for the protection of all persons under any form of detention or imprisonment, close quotations. Principle 6 of the Act provides as follows, and I quote, no person under any form of detention or imprisonment shall be subjected to torture or cruel, inhumane, or degrading treatment or punishment, close quotations. It further states, and I quote, the term cruel, inhumane, or degrading treatment or punishment should be interpreted as to extend the widest possible protection against abuses, whether physical or mental, close quotation. I suspect that the thrust of the aforesaid principle was precisely what operated on the minds of the former authority, which, during the period 2011 to 2012, recommended that consideration be given by the then Commissioner of Police to the installation of CCTV cameras in strategic positions in all police stations, including holding cells. It is this authority's view that the careful implementation of measures such as this would ensure transparency so as to occurrences while citizens are detained and permit a review of conditions of holding cells which, to date, remains invisible to the public eye. The installation of cameras would lift that proverbial veil of protection, revealing not only the conditions under which detainees are being kept, but may also expose acts of abuse by police officers against citizens, or alternatively, frivolous and spurious allegations made against innocent officers trying to execute their duty fairly and justly. Recognizing the importance of this committee's examination on the issues at hand, I now turn over to you, Madam Chair, to direct this meeting in any manner you deem fit. Thank you very much.
Thank you very much, Mr. West. At this time, I would like us to commence the questioning, reminding both committee members as well as the officials who are here with us to direct your questions and concerns through the chair. I would like to, start the questioning by directing a question to the members of the police service. I refer to your submission on page 12, where the question was posed, how long are persons held in cells before they are released or transferred? And question 15, that's question 14 and 15, which asked, what's the maximum amount of time a person can be legally detained in a holding cell? And your answer, which dictated that there being no statute in Trinidad and Tobago dictating stipulated time, detention must be reasonable and depends on the nature of the investigation and the circumstances. Given the fact that there have been some reports coming forward of people being kept longer than they should have or detained in the cells, I want to ask the police service to elaborate on this and what is the usual practice when people are held and detained. What is the usual practice that obtained, and on average, how long are they kept in the cells, depending on the circumstances?
Complete the processing of a detained person and facilitate the charging and taking that person before the courts within the shortest period of time. So that's the usual practice.
So for a general member of the public, if somebody is detained, a family member or so, a community member, if they are detained by the police, what should they expect to be happening to that person by the next day? Should they be going to court by the next day?
Usually, yes.
And what happens in the unusual cases?
Well, in the unusual cases, a person may be detained and investigations are being conducted, and dependent on the processing of those investigations, the detention can be longer than a day.
So is there a limit of time beyond which you can say that the person should not be detained? Is there an upper limit of time?
But there is none stipulated, because the main thrust is about promptness. We need to process detained persons in a prompt manner. So the issue is not about an upper limit, it's about that lower limit. As fast as you process, the intention which is driving the police service is about promptness.
Senator Gobis, sorry, Mrs. Gobis.
Mr. Williams, you keep using the word promptness, but can you explain to us what is meant by promptness? Is it 1 day, 48 hours, 72 hours? What does promptness really mean?
That's why in the explanation, each case turns on the circumstances of the case. Quite recently, we had a situation where persons would have been detained. They went before the courts, and the court make the determination on an application of a writ of habeas, whether the police are not fulfilling their obligations quite consistent with the law, and justifications are advanced as to the issues of detention. What we are guided by is that when a person is detained, the intention is to detain that person, process them as quick as possible, have them before the courts. If that can be done same day, we move to do it same day. If it can be done within a 24 hours, we move to do it within a 24 hours. So the general practice, when I use the term promptness, is as quick as possible that you can process a detained persons to take them before the courts. That is what guides us.
And what reasons you may advance to say and to justify the reasons for the delay? What are some of the reasons you will advance?
I'll give an example. Somebody is suspected of committing a murder. We have a dead body, we have a suspect, we have gathered evidence which affords us the reasonable grounds to arrest that person. We have to ensure that we have a post-mortem done so that a determination, a legal determination is made, not a police determination is made, that that person was, in fact, killed by whatever cause we would have identified from an investigation. That is done through the post-mortem. If that takes 3 days to be done, we cannot proceed to charge that person without the completion of that post-mortem. So those circumstances will dictate that that person who you have reasonable grounds to facilitate that detention is not necessarily charged before that process is completed. And it goes on and on. It turns on each individual case. But the general guidance to police officers is that they need to operate with the guidance of promptness, means that if you detain somebody, all efforts should be made that that person should be charged within the shortest period of time.
So if I may, just before the other members weigh in, what is the, if someone believes they are being detained and the action is not prompt to be able to charge them, what is their recourse?
The recourse is to the High Court application for a writ of habeas corpus. The police are commanded to bring the body of that individual before the court and justify the circumstances of that detention. So there are clear provisions in the law to protect the individual from any abuse of the police.
Senator Hussain.
Thank you very much, Chair. Commissioner, I have an experience with regards to the police and the practice in which they charge. I don't know if you can bring some clarification to this point, but recently the police would have arrested certain individuals for possession of marijuana, and they would have taken these individuals to the police station, and you would expect that it was around 8 p.m. that the next morning they would be brought to court, because it's a very simple charge. It's possession, you have the marijuana, it's possession. Yet the police took an entire day to charge them. They weren't brought to court that morning. They were brought to court the other morning. The justification given is that the police officers were on continuing inquiries on an unrelated matter to what they detained these persons for, so that they didn't have time to come back to the station to charge them so that they could be brought to court on the exact same day. Is that a practice in the police service?
I would say no, and I am not in a position to speak on the side of the police to justify that example that you have spoken about. But I would say no, that's not the practice. If somebody is detained, that person is not to be kept whenever the police complete whatever they are doing, which is unrelated to the matter, and then to charge them. That's not the practice.
Yes, thanks, Madam Chair. Mr. Commissioner, promptness to me is relative, right? How I see promptness would be totally different to how other individuals see promptness. And we are talking about the police service here, so we're talking about thousands of individuals, police officers, who would be charged with ensuring that these individuals are processed when detained in a prompt manner in order to come to go to court, as the case may be. What are the benchmarks regionally, let's say within the Caribbean? Does the Caribbean operate similar like Trinidad and Tobago and use promptness, or are there specific laws and guidelines in order to say an individual is charged or is detained? How do the other Caribbean countries deal with these matters?
Well, as a person who sits on as the first vice president of the Association of Caribbean Commissioners, I would say the practice across the Caribbean is in a similar way to what happens in Trinidad and Tobago. Police officers across the region focus on dealing with offenders. If the word prompt, I'm just using the word which is contained within the law, but if the word prompt is not bringing the best impression, treat with prisoners, detainees in a swift manner. So the reason for that is that the law would send clearly across the police service to all officers that a lackadaisical approach, such as the one described by the member, police going and continuing doing investigation which is unrelated to the individual, that is not promptness. You treat with the matter, you have the evidence, you charge, take the person before the court. If you can do that within a turnaround of 24 hours, great. If you can do it within a turnaround of a few hours, great. We generally try to have a person before the courts, when detained, within a 24-hour period.
And Mr. Commissioner, and you are satisfied as the acting commissioner with the promptness that your service deals with regards to particular individuals. Again, I wouldn't like to, bring specific cases, but as the commissioner, you are satisfied in terms of how the police service is operating when they have detained individuals and ensuring that they get taken to justice speedily?
And I would say yes, I'm generally satisfied. There is always exceptions to the rule. And some instances, we have detention, and those detentions are challenged. But generally, persons detained are brought before the court swiftly.
Just one question. Do you believe that the time has come for some standards to be introduced that deals with what prompt means or what swift means? Do you think it is a time for us now to, as a country, address and define maybe an upper limit of time beyond which a person should not be detained if they have not been charged? Do you believe that that is something that should be looked at?
From a policing perspective, I would say no. I would say the shape of the law as it exists is proper, with all the insulation and protection for individuals. Detention is generally clearly understood that in many instances it requires additional investigation, and that's on the basis on which our system works, and the court give clear consideration to each individual cases when the issues of detention by the police officers are considered not to be in keeping with that kind of promptness that I have spoken about. But if we just put into law a fixed number of hours, it may not necessarily be serving our country in the best way. So from my position, I would say no.
I ask the Police Complaints Authority maybe to weigh in on this. Is it based on what you have seen coming out, the types of complaints coming out and so? I know that you don't necessarily disaggregate the data and look for if it's actually at a holding cell that the complaint may be coming from. However, on this issue of standards, the police commissioner hasn't indicated he does not think at this point in time it is necessary to introduce a standard for the length of time. Does the Complaints Authority have a view on this?
Madam Chair, we have had many complaints similar to the member, Mr. Hussein, has just spoken about, where police officers arrest individuals. Just last night, we were in a meeting, outreach meeting in Arima, and there were many calls from the public that their children were being arrested and detained for 3 to 4 days. They weren't allowed, they were allowed to just bring clothes and to change. So therefore, from where we sit, it would be beneficial if there were an upper and a lower limit of time where the police can detain persons before they charge, because that would give some sense of clarity to how long somebody can be kept in, instead of this blurred, answer of we're doing inquiries, we're doing further inquiries. What does that mean? You understand? So therefore, if it was that we had if it was some set standard, that would benefit, and everybody would know, that would benefit the public in knowing what their rights are, which is very important.
Mr. Jennings-Smith?
I have a general question here, because listening to the submissions of the Commissioner, as well as the Police Complaints Authority, we are guided that policing is a whole multidimensional activity, and it is not solved, or a person cannot be taken to court just like that. Police must engage with extensive inquiries to prove a matter or case that they have before them, to placed before the court. And they are guided by standing orders, regulations, and they are guided by the court. Because, as you said earlier, Mr. West, persons can bring their complaints to you during, and during it could be by the representative, maybe the solicitor or lawyer, and after. I want to clarify something, both by you, I want a response, and by the commissioner. Tell me, do you think a complainant or an officer in charge of a station has a discretion when dealing with matters of the law? Mr. West, I'd like you to answer first, and I'll ask the commissioner to give an opinion on that. If, when a prisoner is on a station, if the SDO at the station or the complainant himself has a discretion to keep a person at a holding bay for overly long period of time.
Well, there's a distinction there between a complainant and a SDO, because there's no discretion for a complainant. That's the person who is being investigated. Correct?
Complainant will be the police officer laying the charge, if I may correct you.
Okay, then. Okay, the complainant is the police officer, and the SDO is the officer who is in charge of the... Well, there will always be a discretion. There has to always be a discretion, you know, because if you do not have discretion and everything's black and white, certain things would not be able to take place. So I think that there should be a discretion, in my view, but the discretion must be reasonable. And of course, as the commissioner says, it could always be taken to the court to determine whether or not that discretion was exercised reasonably or not.
I ask you the question because in your capacity, you have to give directions or you have to give guidance to our public at large. And I would like you to give correct guidance with respect to dealing with matters when persons are held at stations. Because the general consensus out there is that a police officer can keep a person if they feel to keep them a long time. And much is not said about what guides a police officer to keep a prisoner at a station. For example, maybe inquiries, maybe the type of inquiry that the person is doing. We are in a society today where we have crime and criminality run away, right? If I were to put it like that. And I believe that we need to guide people as to what happens and what that officer has before him. So I asked you, I want you to tell me, if you really feel an officer has a level of discretion that he can use, or if that officer is bounded by law, by regulations, by standing orders, and even the court in determining how long a prisoner could be kept at a station. I want that clarified.
Well, you see, it is when the officer goes beyond his discretion and the authorities of the view that they have exceeded their discretion, that is when a complaint becomes a valid complaint and it either becomes a criminal offense or a serious police misconduct. You understand? So that is where it comes in. That is where how we could answer your question. That is when the discretion is exercised in an unlawful manner. That is the issue. But the police officer, they must have a discretion whether or not to keep somebody for further inquiries or not. It has to happen, otherwise officers will be bound and they would not be able to investigate the matter fully and completely. And they would either bring cases to court that will lack the evidence, or they would not bring cases to court. And we don't want that. We need to find a balance between the two.
Great. So basically, I asked that question in determining the definition of promptness. I don't know if the commissioner may wish to respond to that same question.
Well, that question is almost like a difficult exam question. because the way it is posed, it's difficult to answer yes and no. Police officers generally operate with discretion in fulfilling their functions, but they also operate with the guidance of the law, and the law is made up in different forms. You have the statute law, and you also have guidance from case law. So therefore, the determinations by the courts actually dictate how the police officers are supposed to operate. They are also guided by the internal rules, where we have standing orders guiding the behavior of officers in relation to particular things. And in this instance, we are speaking about detention, and we are looking at lawful detention. So it's all made up with all those factors in guiding you when somebody is detained, how long that person should be detained for. But officers are continually trained, retrained, and advised that there should be no abuse of policing powers, and they need to focus on taking a person before the courts once they have sufficient evidence made out against that individual to prove a case, take them before the court in a very swift manner. And the usual practice is that there is a turnaround within 24 hours. If it's a weekend, then they go to court at the first opportunity, which is the Monday morning. And that's the usual practice. And it's the usual practice that we have adopted in Trinidad and Tobago.
There is a concern by the public that officers arrest persons and then continue inquiries. Do you wish to comment on that?
Well, the law provides for it. So yes, I would say yes, officers arrest persons and continue inquiries.
There's also a view in the public domain that it is easy for a police officer to victimize persons or victimize a community by continually picking them up and detaining them for a couple of days, and then picking them up, letting them go, and the cycle continues. What systems are in place to ensure, and you mentioned it about the abuse, and I think it was picked up here in the question asking about arrest first and then look for evidence after. How can we assure the public, and what systems are in place to ensure that that kind of cycle and that kind of abuse does not take place? What oversight is there to ensure that that doesn't happen?
At the police station level, we have supervisors at every single police station. And we have first-level supervisors who are corporals and who are accountable and responsible. So it's not just the constable out there go arrest a person. When that person is brought to the station, that supervisor has a responsibility guided by the rules of the organization to make an assessment of the circumstances. And if he's not satisfied that the detention is lawful, he is to make the necessary records and release the individual. That happens in times when he's not satisfied. He's the one, first-line supervisor. And beyond that first-line supervisor, he has a supervisor of that supervisor. Normally it's the sergeant, and stations are generally manned by inspectors. So we have a whole system to ensure that persons are not abused by police officers in this loose manner where people say just pick up and just bring in. That's not the way policing is done. There are a lot of perceptions out there, and those perceptions may not necessarily be guided by the truth.
That's why it's so good to have you in here to put it out there so the public can understand how the system works, and therefore they can have a better appreciation of when the police do their work, what it really means and how the systems operate. Senator Oversight.
Thank you very much, Madam Chair. Madam Chair, through you, this is a question to Mr. West. You said earlier on that you received numerous complaints of police taking a very long time in order to charge or even to release the individuals who are detained. In your experience at the authority so far, can you just give us a rough figure of maybe how many of those complaints were made and what actions, if any, were taken on any of these complaints?
Mr. Hussain, I don't want to speculate and give an answer in a vacuum. Can I have it later on in writing to the committee, if I could answer that question?
Yes, yes. But has any action ever been taken on any such complaints regarding of this nature, sorry?
Well, what we do is we are limited in that once we do the investigation, we make a recommendation either to the DPP or the Commissioner of Police, as the case may be, and then they take it further, yes, as they see fit.
Okay.
Mr. Ford?
Yeah, to Mr. West. Your PCA, do you all do proactive investigation? Is the association authority set up to do an investigation before they receive any complaints?
Well, can I ask Mr. Miguel, to answer that, the head of investigations, to answer that?
Yeah, no problem.
We don't, as a matter of course, do proactive investigations. However, we can imagine a situation in which allegation of corruption is made, and we can foresee us having a proactive measures in terms of proving or disproving such a complaint. But generally, no, we don't do proactive policing. You see, we are reactive by nature because people who have experienced injury, loss, or hurt at the hands of the police, they come to us, and so, you know, we do the investigation from the back end rather than forward. However, our annual report, it does paint a picture of the type of complaints that we receive on an annual basis, and it is instructive to the police service, the amount of complaints that we have in terms of, like, let's say, for example, assaults, so that they can adjust their training and their policies and so on to deal with that in a proactive manner.
Are you all adequately staffed?
Right now, we're dealing with a complement of 23 investigators. Ideally, we would like to have a team of 26. We have a complement of 8 attorneys on board, and ideally, we would like to have a complement of 11. I have to say, with the team that we have so far, we're very proud of the turnover that we've had for the year. I believe it's a figure close to 800 for the year, and this has been a huge, it's been more than double, and we're very proud of our team of 23 and 8. Do we need more? We'd be very grateful to accommodate more. Because with more, as I said, we've more than doubled what we did over the previous 2 years. With more, I mean, we could try to move a mountain. So we'd be very grateful if that consideration is taken on board, but we're doing very well with our 23 and 8. Thank you, Madam Chair.
That more is in anticipation in anticipating that the police will have more complaints against the body?
Well, the police so far haven't had any complaints. I think they love us. I don't think they've had any.
But why would you want more? Why would you want more then?
We don't, Honorable Chair Lady and Honorable members of the committee, we would be happy if there are no complaints at all. We would be happy not to initiate under Section 26 of our Act, which we can do. I think all of Trinidad and Tobago would love to welcome that day. But the sad reality is that the number of fatalities, fatal killings, and shootings have increased. I'm sorry to say that. And we're not looking at a decline in terms of what we've been looking at. We've been looking at an increase. So the view that the Honorable Chair Lady shared from members of the community who feel that they've been detained and then they have to await the inquiry, that comes from very poor communities in Trinidad and Tobago. And it's not unique to one district of Trinidad and Tobago. You find that complaint and it's on the increase. And our 23 and our 8 continue to look at that increase. And I just say in passing, through you, Madam Chair, the Honourable Member, Mr. Hussain, had asked about it. The remedies available to these poor people are expensive. You're talking about hiring attorneys. You're talking about bringing a habeas corpus application, which is not cheap. And you're talking about bringing a matter to court. So our 23 and our 8 can't assist with that. But I hope I've answered your question, Honourable Member.
Last question on this topic as I have a. In terms of your investigative team, all have policing background? What's the background in terms of your investigation team? A compulsory nature in terms of their necessary background?
Well, at the start of the authority in 2010, we started off with a cadre of officers from the Special Anti-Crime Unit, ex-TTPS officers and so on, who had the investigative acumen necessary to do the job. However, I am advocating to actually build homegrown team now. We have started with a couple of members so that we can sort of insulate ourselves from the law enforcement culture, because after all, we are a civilian organization, and we intend to develop a civilian oversight culture within the PCA investigative unit.
Just to be clear, there are no serving police officers in the PCA. We have retired and officers and officers who have resigned, but there is no serving Trinidad and Tobago member of the police service in the PCA.
Mrs. Gopi Singh.
Mr. Williams, I would like to just revert to a statement you previously made with respect to the habeas corpus. We would understand and we are mindful that persons who are usually detained at these holding cells belong to the lowest rung in the social strata. To bring a habeas corpus to the High Court is relatively expensive. So if this person is detained at the holding cell for an inordinately long time, what happens to this person if he cannot procure the funds to bring a habeas corpus?
I think I spoke about habeas corpus in a particular context. And I also spoke in another context in relation to the system that we have in the organization. We have a system I just related where we have supervisors. First level supervisor is corporal, second level supervisor is sergeant, third level supervisor is the inspectors. And then we have all the other ranks, because a police station operates within a division, and within that division you have a head of a division who is normally a senior superintendent. So it's a whole rank structure, and everybody is accountable for an individual who is detained. So it's not one person, the person who detained him. Everybody else is accountable for that person who is detained. So they have a direct responsibility. So we are not speaking about the only recourse. We're speaking about an organization with a system to ensure that there is no such abuse. However, sometimes when a person is detained, for which we consider justified, and we need to understand that according to the type of matter, we engage discussions with the Director of Public Prosecution on a consistent basis. And the Director of Public Prosecutions, in many instances, once the detention is a matter of a few days, will either dictate that that person is released and you continue that investigation, or dictate that that person is charged. So we also have that feature of the Director of Public Prosecution playing a part in the length of time that a person is detained. But the police service doesn't focus on detaining persons at the lowest rung of society and say, well, we're picking out lowest rung of society to detain them for any length of time. Investigations are done based on offenses, and persons are not just plucked out without police officers having good reason to detain persons. So we have to understand, and sometimes we operate in a particular way in this society, that we don't understand that within the realm of the society we have criminality. We have criminality. And there are different forms of criminality, but the normal offenses which affect us on a daily basis, not by way of my choice, but a lot of the people who commit those offenses are the lowest rung of society. So you do in fact find that that engagement with the police will have many persons at the lowest rung of society within the hands of the police as being detained.
Well, Honorable Mr. Williams, sorry, you have just agreed with what I'm saying. The persons who are detained, they cannot afford to get the money to bring a habeas corpus. And then it takes you now to the next level. How many persons are in the upper echelons of society detained at the police station? How many you have had thus far?
Is it a question that you're now asking an answer for?
Yes, certainly.
Well, it varies, and if it's a question that you require an answer for, it varies, and we would have to tabulate that information for the committee if it is so required.
If I may, and not to cut across, but I think we're speaking in generalities here, and I think the general point that is being made, and it's been made by a couple of people, is that the recourse is expensive, and therefore, if you can't afford the recourse, what is the situation? But I think you have, you've said, you've laid it out, that there are systems in place with respect to the levels of supervision that should be able to weed out any unjustified detention. Right? So I think that's the general point we are making, and I think we've kind of we've made it, and I feel as though now maybe we can move to another point. We'll have Mrs. Jennings-Smith and then Senator Moses.
I just want to, based on what we have been discussing this morning, I noted here from a document presented by the police service. In 2014, we had 1 report of false imprisonment. 2015, we had 1. 2016, we had 2. And 2017, we had 2. And I want to focus really on what we are here this morning to look at. We are looking at really conditions at treatment of detainees and conditions at holding cells. And I suspect that these reports would have come aboard from false imprisonment. Mr. West, Director of the Complaints Authority, are you aware of these numbers?
Well, I would need to see the names because to collate with our data, but so I don't know.
Because I wanted, you see, I am still on the point to close off, because I wanted to know to what extent this particular issue is impacted on in terms of numbers. And when I look from 2014 to 2017, I see a total of 6. So I want to know if that number is synchronized with your department, because I think this was presented by the TTPS. So are you in agreement with those are the numbers of persons who have been at police stations and reported?
Right. May I respond, Honorable Chair, through you? I have to apologize that when we first did the first look through on the automated system, we didn't immediately fine-tune the search as it relates specifically to cells. I have to also apologize that I've not had the benefit of looking at the data that was provided by the TTPS to the Honorable Committee. However, when the Honorable Member refers to the figure 6, having done the search and spent some time doing a second search, we have also found 6. I don't know if they match the TTPS's 6, but I don't know if the committee is interested in hearing about our 6 that we have clearly identified, having gone through 1,890 complaints.
You see, we are looking at abuses.
Right.
And I have to highlight the number
Sorry.
Yes.
Remember, we are looking at treatment, right?
Well, yes, treatment.
So I want to be very clear.
So we are looking at treatment.
Let me just make an interjection. Be very clear that what we are looking at is treatment. We are not trying to be pejorative. We are looking at the breadth of treatment and what the systems are in place. So if we are identifying 6 cases that the police have said have come forward to make complaints to the Complaints Authority based on their treatment as detainees, then that may correlate with what happens at the Police Complaints Authority. It may be the same, but so I want to be very clear, we are not being pejorative. Our role is to investigate. And so we are looking at what treatment is missing out and what systems are in place.
Right. So now that we have established was 6,
with the greatest of respect, I'm not too sure that my 6 matches the TTPS.
Okay. So I'll take back that. But now that we have established it's around 6 reports we have gotten so far. I want to know if you had completed inquiries and if you were satisfied upon the completion of the inquiries into those reports.
In order for me to do it properly, is the committee minded to indulge me and go through the 6?
I don't have names. I just have a number.
I'm legally, I cannot reveal the names in any event. What I can assist the committee with is pursuant and in furtherance to the document that we provided. We can assist with the year. We could assist with the time the investigation took. We can assist you with the police station, the nature of the complaint or the allegation, and we could assist you with the division in which the complaint came to us.
I'm really asking this question to clear up something, because in quantifying or in coming to a level of understanding of the amount of situations that happens at a police station, I looked at the numbers for the year, and I wanted to know the extremity or the non-extremity where these matters happen.
So in terms of the most extreme, we've had to deal with people who were found hanging in their cells, people who had been allegedly beaten to death, people who had been wrapped in plastic and beaten, people who had, at the lowest end of the scale, they had been slapped or threatened. And I'm looking for another minor one. Most of them, they had been beaten with a blunt object. They had been put into a cell with a, let me be very diplomatic with my language, with a rival, alleged rival gang member, and they were allegedly beaten by that person and stabbed with a surgical razor, which somehow found itself into the cell.
If I may, I believe that what is trying to be established is this a very pressing issue? Is it an important issue? And I submit that it is important, because what we may be seeing coming to the Complaints Authority would be people who actually come. But there will be many other people, and we see it in the papers all the time, complaining about police picking up people unlawfully, and they would use the term unlawful, meaning that they don't think it's justified detention. So the issue really is, and what you've called out there, speak, of course, to the extremes where things have happened in the cell, you find dead bodies and that kind of thing. So, member, I don't know if that answers your question or if you want to ask further.
Doesn't quite. I was really referring to the number of complaints because we are quantifying it. And I was really referring to 6 in 1 year, in six complaints over the period 2014 to 2017. 6 reports, right? So I wanted to quantify it. I was not really looking to say extreme of the action that took place, because then you'd have to investigate those activities. I just wanted to bring to light here, there was 6 reports over the period 2014 to 2017.
And similarly, from the PCA's point of view, because I haven't had the benefit of seeing what the Honourable Committee has seen, for over the past 5 years, from 2017 come back, we have also considered at the very least, because this is what we pulled from our second manual search, 6 complaints from 2013 come up straight until 2017 that we have investigated and are still investigating.
Senator Moses.
Thank you very much, Chair. With your permission, if I can change. I would like to know how many police stations, or preferably the percentage, where facilities, holding areas exist for juveniles.
Just to share, there have been 2 such stations specially outfitted to treat with juveniles in keeping with the new laws. And we have, as of this week, received a release of funds so that we can outfit 2 more stations.
Mr. Ford?
Care to identify the 2 locations? Is it public knowledge?
Yes, Marcus St. Joseph, and I think it's Gasparillo.
I'm sorry, just to interject, Marcus and Joseph does not have the cells already?
Has.
Right, but what are the two new ones, if that is what he was asking?
No,
or I'm interested in asking as well.
Marval and Belmont.
Can I ask on what basis the stations were chosen?
It really had to do with the police service having to meet with new requirements urgently. Marcus and Joseph was being constructed, and we had an immediate opportunity to make an adjustment. And we made that adjustment with Marcus and Joseph. We needed to identify that the children's court will be coming on stream, supposed to be coming on stream since late last year. And we focus on there'll be a court in the southern area, court in the northern area. And we looked at how we can support that. So we focus on having an adjustment made in the southern area. Port of Spain being dominant by way of number of cases to cover the broad area. We also then focus on there being no additional new station for which we can provide. We focus on making some adjustments to existing police stations, and 2 existing police stations were identified. So it's a progressive consideration, but where the juveniles are to be treated, children detained, we sort of separate the detention activities from adults. So in Marcus and Joseph, the cells at that station are dedicated to the juveniles. It's not facilitating adult prisoners. Adult prisoners will be effectively housed at St. Joseph Police Station, which is reasonably near to Marcus and Joseph. So that is what helped guide us as we go forward in treating with matters. Over time, we expect, as we get the kind of funding arrangement, we will be able to outfit many more stations.
So if I could just recap, the 2 are Marcus and Joseph, and that have existing facilities now, and Gasparilla. And the 2 to be added would be Maraval and?
Belmont.
Belmont, okay, yeah. Thank you.
Right. So juveniles in the southern area, how will they be taken care of? Gasparilla.
Yes.
Right. So therefore you'll bring all to Gasparilla, and then on this side we'll bring all to Marcus.
And that's just temporarily as okay, we focus on treating with the demands of 2 courts to treat specifically with children.
Are they overcrowding at holding cells?
Generally, no. If we have persons detained, like we have a major operation, we have persons detained, we then distribute the detained persons to other police stations. So we don't just, if it's an operation out of one location and the number of persons detained are more than we can provide for at that location, we look at other police stations to distribute the detained persons.
How often are holding cells inspected?
Well, there's a requirement for a daily inspection.
Daily, once a day?
Daily.
Right.
By whom, if I may ask?
By the officer in charge of the shift at a police station, so they have to check the cells before you sell prisoners, so that nothing is available at a police cell.
How often are holding cells cleaned?
Daily too.
If I may ask, according to the body of principles that is adopted by the United Nations in 1998, and of course we are signatories, places of detention, Principle 29 states, places of detention shall be visited regularly by qualified and experienced persons appointed by and responsible to a competent authority distinct from the authority directly in charge of the administration of the place of detention and imprisonment. How do we, in our present system, comply with this principle?
Well, we utilize a system of visits and inspections, which is based on the management of the station. we have an additional facility of visit and inspection, which is based on the assignment of external persons to visit and inspect stations, and that's basically done on a monthly basis. But the daily exercise is done by the officers attached to the station.
And who inspects on a monthly basis? Who is the independent body?
Persons assigned generally by the DCP operations and the divisional command. So they will not be the officers assigned to the station, would be persons other than assigned to the station.
But this principle, if I am reading it correctly, speaks about a competent authority distinct from the authority directly in charge. If I'm understanding you to say that it is police officers who are inspecting the cells, would that fall in line with the guidelines of this principle?
Well, we have been operating on that basis that the persons directly in charge of the station inspect on a daily basis. Persons who are not directly in charge of the station, and we speak in the context of police officers. So we are not looking at any external agency other than the police service. So we speak to two different groupings of police officers.
I want to ask the Police Complaints Authority, maybe, if they can weigh in on that, maybe they're legal, on should it be, based on the principle I'm relating, does the current system agree with what the principle really is stating? What is your opinion on it?
From reading what you've just read out, Madam Chair, and listening to the Commissioner, they are not in agreement with the recommendation, because it's a different officer from a different station inspecting, which is the same body, which should not happen. I suspect it may be a matter of budgetary constraints. That's why they do it in that way, but I don't know. But from where we stand, it should be an independent body outside of the TTPS inspecting the prison cells.
Commissioner, is it that this system operates because of budgetary constraints, or is it that your understanding of it and the understanding that has pervaded has been that it is sufficient for the police to investigate the police cells?
Well,
or to inspect, if I put it up.
But that's the long-standing practice that we have adopted, and the police service sought that practice to comply with what is provided. So that's our view. It wasn't based on budgetary constraints or anything like that.
Thank you.
In a somewhat linked fashion, I would just like to focus on in cases where it is apparent that mental health issues might be involved with a detainee or with detainees, if they are mixed in holding areas with other detainees.
The police service has some level of limitations in making some what we can call clear determinations on mental health detainees. We have a standing order which guides how we treat with persons who are identified as mental health detainees. And we sought to also expose our officers to some level of training to deal with mental health detainees. But the determination of persons is not one which is easily made. So where we have some level of suspicion, we seek the support of the court in addressing issue around mental health detainees. But if it is clear that somebody behavior at a police station is so extreme, course of action is taken to separate that individual from other detained persons.
Thank you, Madam Chair. I just want to go back to the point on juveniles. Those juveniles who are detained in localities away from the Gasparillo or the Maracas St. Joseph station, how do we deal with them? And also in Tobago, because I didn't hear whether or not a juvenile station is being outfitted in Tobago.
Detention of juveniles has been a long-standing issue with the police service. It's not a new thing. So we have detained persons at police stations, and once we are detaining juveniles, we separate them from adults. That's the normal practice. What is being brought to bear is clear distinction of treatment, even the manner in which these cells are to be constructed and outfitted. And that is the context in which we speak today in relation to special cells for juvenile offenders. But in all locations where juveniles are detained, there's established, clear rules, guidelines, and practice that they are detained in cells separate and apart from adults. So we do not mix juveniles and adults. So it's common practice to detain juveniles, and they are detained in cells according to our normal practice. There is a new demand on the police service to treat juvenile offenders in a special way with specially designed police cells. And that is where we speak about those areas such as St. Joseph, where we are now meeting the demands of the specially designed cells. But normally, juveniles are detained across the country at police station cells, but we separate those juveniles from adults.
And the Tobago, is Tobago going to get one of those stations with the...
It's our intention. You see, as we go forward, it is our intention to outfit as much stations as possible in this special way. But everything is driven by money.
Okay.
And right now, we made some requests. We only received a release, as I said, a matter of days now, and we are moving at a pace to outfit 2 stations based on that release.
Mr. West, has there been any complaints regarding mixing of adults and juveniles at any stations to your authority?
From the, from the data that we had so far for the past 5 years, the answer is no.
Okay, great.
If I may, with regard to the fact that there is no upper limit on how long a detainee may be kept at a station based on investigations, and it is, of course, at the discretion of the police officers and at the different levels of supervision to determine whether or not the person is being kept unfairly. What provisions are made for someone that is kept for a number of days at the station? Are there showers? What provisions is made to ensure that that person retains their inherent dignity, as is outlined in body of principles, as Principle 1, which says all persons under any form of detention shall be treated in a humane manner with respect for the inherent dignity of the human person. How are they accommodated in this way?
On the rare occasion, and I need to put that way because we may miss it, persons being detained at police stations for longer than a day or 2 is a rarity. It is not a normality. So it's not the normal thing for persons to be detained longer than a day or 2. On the rare occasion that a person is detained for a longer period of time, the police service facilitates the person to be allowed the opportunity to have a bath, allow family to bring in additional change clothes if those things are necessary. But it is only on a rare occasion. Out of the thousands of persons detained by the police service, it's a matter of a few persons are ever detained longer than a day or 2. I just wanted to make that clear because we have emphasized the detention of persons for long periods of time, but that's a rarity and it's not a normal thing.
Senator Hussain.
Thank you, Madam Chairman. The children of a prisoner who has no relatives or other persons to take charge of them may be taken charge by a female officer and then taken to a place of safety. If there are no female officers present, what takes place?
We will then get a female officer to the location where the child is to be identified. But the police service today has a large number of female officers. So we should not have any difficulty in having female officers available to treat with children.
Okay, thank you. I just wanted to make sure that we will find a female officer. Sure. Because I could tell you from in the municipal police, we had interviews recently. And out of the 1,200 persons came, our 900 were female officers. Yes. So, but you still want to know because the public comes and the case might come up.
Mrs. Guiding Gopi Singh.
Yeah, thank you, Madam Chair. Mr. Williams, I have been looking at the responses from some questions here, and one particular question and stated, accommodation shall meet all requirements of health, due regard being paid to climatic conditions, particularly to cubic content of air. And I was trying to figure out what is the required cubic content of air in a holding cell, and who measures that and how often it is done. And perhaps I don't want Mr. Moore feel that he's left out of all this, and if Mr. Moore perhaps will want to engage us.
The language is one which took me back with the cubic conditions of air. So as I said, I needed to just make a few amendments. I highlighted that to the chairman at the beginning. There are some areas for which I wanted to make some amendments because we have really no set way of measuring that at the stations.
Yeah, actually, I was contemplating the same policy in terms of hearing from another one of your officers. I want to go to the regulations. The Police Service Regulations, Part 9, from 100 to 113, provides for the custody and care of prisoners while held in cells at police stations. And I want to go to Regulation number 101, which reads, a prisoner shall be searched on arrest, on arrival at the police station, and immediately before being placed in a cell, and again on being taken from a cell. And I would presume the same thing would go, taking him to the courthouse, bringing him back as the case may be. A video clip hit my phone earlier this week, and I'm sure it would have probably hit a couple individuals, where in one of the police trucks, or probably the service provider, where some individuals were engaged, prisoners, they were speaking and everything and making comments and what they were doing and so on. How is that possible, or how in that particular instance, how was that possible? How could that have happened? I don't know if any of you all saw it, but it's a video clip that was circulated just earlier this week. So,
you indicated that you may want one of the others to answer, so you can pick any other one we would choose to answer.
I don't want to come across as delegating for you, Mr. Commissioner, right? I mean, that's your authority, but there's operations, there's South, there's crime, there's Northeast,
And if
I may... How Tobago will probably handle it, I don't know. Yeah, probably good to hear Mr. Dula.
Yeah, but remember, if I may, and I think I had the privilege of seeing that video yesterday, and I would have asked for some information so that an investigation we can pursue an investigation. In fact, just to mitigate any of a repetition of that, yesterday, all of the divisional commanders, we would have met with Prison Authority as well as Amalgamated, the provider of that escort service, just to see how we can probably identify gaps and tighten the situation in relation to something like that not reoccurring. But if we go to the regulations, And if the regulations was in fact complied with to the letter, that situation should not have happened.
Now, added to that, is there a possibility that blame could be provided to the service provider? Do you think that could come about in an instant like that? Because again, I'm just going by examples. You would see 3 service provider trucks going down the road with prisoners. Well, again, I wouldn't know how much prisoners are in the vans. You would see probably 1 outrider. There may be 2 vehicles with 2 police officers that drive and so on. And again, I would not know what happens at the cell. We have some attorneys here, I don't know how it would work out. But in terms of it happening, could the service provider have the opportunity, could they search these individuals? They have the authority to search these individuals and so on, or only the police officers?
The onus really is on the police officers to have these people search and sell. Whether the cell be in the transport vehicle or at locality, at a station, or in the court cells, the onus is that of the police officer.
If I may, I want to return to an issue that dealt with the man hanging himself in the St. Joseph Police Station in 2017. Now, the chairman of the PCA would have mentioned the CCTV system. And I saw in the police regulations that these cells are supposed to be, somebody's supposed to walk by every half an hour. So using this as a test case, I want to understand, in instances where things obviously go wrong, how many police stations are outfitted with CCTV, or are they outfitted with CCTV? And in response to that kind of system failure, right, that would have happened and resulted in someone losing their life, was an investigation launched? Has that been concluded? Have disciplinary measures been taken against anybody found culpable? What precautions have been taken now at the station? I'm using that one as an example of what happens when the system fails. Because, Police Commissioner, I understand that there are systems in place, but I think we all have to agree that regardless of how many systems of supervision there are officers who will do things wrong and who are doing things wrong, and that officers have faced the court and come before the court and have been charged and convicted. So we understand that even though we put systems in place, there are failures. So using this as an example that happened last year, February the 8th, what happened out of this, and how are we now to be reassured that when things happen like this, the systems work in order to mitigate against any further recurrence of that? And what's really going on to make sure that these things don't happen?
Well, I'll ask the ACP Northeast, ACP Jacobs, to speak specifically about the St. Joseph Police Station incident that falls within his jurisdiction. But to speak about the cameras, I would share with the committee that we have outfitted all police stations with cameras to cover the area of the corridor to the cells, and not to the cells. So we have not placed cameras in the cells, we have placed cameras to cover the corridor
Can you
to
just
the
give us an
cells.
idea of how recently that outfitting would have happened?
It would have been over a period of time, but as of 2017, we would have completed outfitting all police stations. As relates to St. Joseph Police Station, that's a new police station. And while on the face of it, we thought we had designed that station cell to prevent a situation of somebody being able to hang themselves at that station. We quickly responded to that, and we have made adjustments to the design of the doors to the station cells, and also we have identified a model of how a station cell is supposed to be presented to eliminate persons being able to hang themselves at those station cells. So all the new stations are now being redesigned to treat with preventing any individual from hanging themselves at a police station cell. So St. Joseph has been redesigned, so we should not have recurrence at St. Joseph, Maracas St. Joseph, Besor Street, which has just been completed, and all the other stations that are now being constructed are going consistent with a new design to eliminate any opportunity for someone to hang themselves in a police station cell. We have to revisit all the other stations which are existing for the purposes over time to be in a position to give that assurance that they are so designed that a person will not be able to hang themselves. And sometimes it is kind of almost strange to see how a person intends on killing themselves, how a hanging takes place at a police station cell. It's not that they come in with a special rope or anything like that. They use items of clothing and consistent with human rights. We can't strip the individual of their clothing at a police station cell. So that's why we now are designing.
Used, so I don't expect that we'll have all prisoners with no fans. So I agree with you.
Yeah, so we now trying to ensure that the cell does not provide any facility within it which somebody can attach item of clothing or anything like that to hang themselves. But we are doing that now with all the new stations by way of a redesign, and we would have to revisit the other older stations over time. But I'll ask ACP Jacobs to speak specifically about that matter at St. Joseph, to share with you whether that matter has been fully investigated and any course of action by way of discipline.
Yes, please, Madam Chair. In relation to that particular investigation, you said earlier that sometimes persons may fail us. In this instance is where we had the situation where the technology had failed us. That incident happened just about 2 days after the St. Joseph police station was actually opened. And you had the CCTV placed there. It was recording everything, but the officers at the reception area was unable to see what was happening in the cells. So after we saw what actually took place, and it happened a few minutes after the person was placed in the cells. As you are aware, the regulations place the responsibility on the officers to check on the cell every hour. So in fact...
Sorry, is it hour or half hour? Because I believe your submission said half hour.
Right. Now the regulations speak about every hour, but we have advanced that to every half an hour.
Yeah. So we do it every half an hour. The regulations state an hour, but for our purposes, we do it every half of an hour.
One more clarification before you continue. The commissioner, acting commissioner, indicated the CCTV cameras are placed in the corridors leading to the holding cells. You are indicating that they are actually on the holding cells, and therefore you would have seen exactly what took place?
All right, this incident happened actually on the gate of the cells, inside the cells, but on the gate, where from where the CCTV is located, you can see where the gate is located, because it actually happened on the hinges of that gate, the hanging that took place. So the CCTV was able to pick up what took place from where it is located.
So it was a malfunction of the technology that would have allowed the monitoring officers not to see what was happening?
Yes. All right, and that was corrected, and also the work was done in relation to the hinge, and that was also corrected. The investigation, it was sent to the Professional Standards Bureau, and it is reached at a stage now that we're waiting on an outcome from the Professional Standards Bureau in relation to that particular investigation.
One more quick question. Why are these CCTV cameras placed in the corridors where you can't see into the cells? Is that the best placement for them?
Well, it really has to do with the issue of privacy. If you are placing the cameras covering the inside of the cell, it has to do with the people's privacy. So that is part of the reason. As ACP Jacobs speak about the St. Joseph situation, the camera would have covered, and also you would have been able to pick up the cell. The incident there occurred right on the cell door. Even though adjustments were made in the design, the hinge is what was used as against a bar. We've changed away from the bar because you can simply tie something on a bar. So that's where the design still did not allow us because he used the hinge of the cell door. But it is generally placed in such a way that it covers the cell, but not to view the inside of the cell. So we're not focusing on the inside of the cell because it has to do with privacy.
So therefore, even in instances where, and I'm going back to some of the things that were cited by the Deputy Director of the PCA, where stabbings may have happened inside of a cell, it means that regardless of whether or not there's CCTV, that is not going to be able to help with those types of circumstances.
I'm very grateful, Madam Chair, because what had happened is, this is one of the recommendations that we made in 2011 and 2012, and we understand and we agree with the philosophy behind not having the cameras trained directly inside the cell. But part of what the research revealed is that in other jurisdictions, the way they got around it is, well, they did throw a lot of money at it. That is to say, when we are protecting the basic human rights and your right to privacy and your right, and a lot of them relieve themselves in the bathroom, in the cell as well, you don't want to have cameras. Nobody would like to have a camera in the cell viewing that. But the way that the other jurisdictions got around it is that they put the bathrooms in another area. What they also did is they at least one cell for certain types of inmates, and it's not inmates, sorry, detainees, at least one cell would be outfitted. And the way they got around any breach of a human right would be that the area where the bathroom facility would be, whether it be a bucket, whether it be, I mean, I hate to use the primitive language, but that's what we may be talking about. It was pixelated. So that little corner was pixelated, and that is ideally the best case scenario from an investigative point of view. Because in our experiences, when we've had the benefit, at least in one case that we can clearly speak about, of an incident where a detainee had serious head injuries and died subsequently, the officers were exonerated because the footage on the corridor, and we only had the benefit of the corridor, it showed that he actually had headbutt himself. I can't think of a more elegant way to put it, but he had hit himself so violently on the cell, on the metal bars, that he ended up having a head injury. The officers were also not to blame, and I want to quickly add that part, because he did show movement. So when they were monitoring him on the digital system and on their camera system, he continued to move. So they didn't immediately pick it up, and unfortunately they only picked it up after he had died. But one cannot escape the usefulness of cameras in the cell once we are able to protect the human rights. And it's not only I don't mean to belabor the point, but it's not only the cells that they recommend other areas as well. And I'm sure the commissioner is already familiar with this, and the committee is familiar with this. But the footage has helped us. That footage has been of great value to the PCA.
Thank you. Senator Hussain.
Thank you, Madam Chair. With respect to a person when they're detained, the only right basically that they're deprived of at that point in time is their right to liberty. So all the other rights are still in effect. And I say this to raise an issue that recently we saw that there was a certain number of Muslim persons being detained. My question is whether or not these persons are allowed to practice their religion while being detained, because I'm a Muslim and I would understand that the area in which you pray must be clean, and the persons themselves, before they engage in religious activities, must clean themselves in a particular way. Does the police allow for these persons to practice their religion while being detained?
I would say yes, as far as can be permitted.
We have had we have many complaints of the cells being very filthy. How would we allow persons to be praying inside those cells?
Well, maybe for my clarity, in order to respond, when you speak about their religion and their religious practice, are you saying that they should be taken out of the cell and permitted some special location in the station to pray?
Well, that is what I'm asking, whether or not that is done, or...
Well, I can answer that. That's clear. Persons who are detained in cells at the police stations. We seek to have those cells cleaned and maintained at a certain standard, but no person of any religious persuasion is taken out of the cell and placed in any other area of the police station to pray.
Thank you.
I think, too, just to be fair, people have different impressions of what filthy is and what dirty is, and so therefore you would have some subjectivity there that may be difficult to accommodate on all the bases. So just to throw that into the mix as well. Mr. Jenny Smith?
Having listened to some of the answers given here this morning by the Commissioner, I want to ask you, what arrangement is there in place on a continuous basis to ensure that first responders, because when you go to a station, you see a lot of first responders. They are the ones who are in the majority at the police stations. What can you tell us now is in place to ensure that they can answer to some of the questions we posed to you this morning in similar fashion, in that they are sensitized to the rights and privileges of persons in custody? Tell us, what do you have in place at this present time to guide young officers who are the first responders and the majority at a police charge room on a daily basis?
And just as we are sharing around the answering, I have the privilege of the ACP Northwest, who just came out of the police academy as the head of the police academy, to give you as a perfect answer that she can give in relation to the training programs.
Good morning, Madam Chair. As part of the training programs for the recruits at the academy, the trainees are all sensitized, at least they're all trained with respect to the regulations, which surrounds the regulation which provides for the custody and care of prisoners while at stations, while at the police station. So they are made well aware of all the rights and privileges that the prisoner should be afforded.
Now, being a police officer myself, I can speak to what you just said. In the past. And I want to point out that what I want to ask you really, I know of that training. What do you have in place in service training when you have officers in the field, officers at charge room out there? What program do you have to ensure that these issues are brought to bear to them in updated fashion? What program do you have at this point in time to deal with people, not training program that you have when persons are being trained? I'm talking about police officers out there at charge rooms. What program of activity you have for them at this present time to update them and to enlighten them about rights and privileges and things that are happening? Because, for example, only last week we saw where somebody was arrested, and when the matter reached the court, it was thrown out. So that what happened in that charge room there when that person brought in that individual? So I'm talking about that. I'm not really referring specifically to that matter, but I'm speaking to the training afforded to officers in service training to give them that level of confidence and autonomy and authority and knowledge in dealing with persons brought into stations.
Just to share with you, I think the ACP started with the recruit training, preparing the individual for the outer world of policing. On an ongoing basis, we continue to train officers. We have in-service training program, and it's part of the mandate of the police academy to continue with our in-service training program for serving officers as we develop them and reshape them. And at the station level, the officer in charge continues to remind officers about what is required in carrying out their, what we can call station daily functions. And that is done also by way of lectures at station level. So at each station level, persons are reminded, they are guided, and by way of clear demonstration of the supervisors of how things are supposed to work, they are effectively mentored by the supervisors at station level to function consistent with the rules and regulations, and they are encouraged to continuously refresh themselves with the regulations and the standing orders which guide operations at station level.
That being so, Mr. Commissioner, why is it in your presentation here, we have where you answered to provide the number of investigation into police brutality cases at police station. From 2015 to 2017, we see a rise that in 2015 we had 8, and in 2017 we have 20. Are you satisfied that that training program that you have for officers at station is working? Bearing in mind that we see a rise in these matters?
Well, it's not only the training. It's one thing to do to give training is about officers complying with rules. And when officers do not comply with rules, there are sanctions, and that's where the disciplinary process comes in. So those who do not comply with rules have to face the sanction that are imposed by way of the organization. So the numbers are not consistent with not training. It's about us imposing the necessary sanctions by way of discipline.
Are we saying that the sanctions are not carried out? Because clearly in 2015 we have 5 cases of police brutality at police stations. And in 2017 we have 20. Did you do a study to determine what exactly were the causes for this present situation?
Well, we have not launched a separate study to identify why we moved from 5 in 2015 to 20 in 2017. But what I want to share is that we have been imposing sanctions, and in cases of police brutality, many officers have even faced the courts on criminal charges of police brutality. And one instance in Sangre Grande, 12 officers have been linked to an incident, and all 12 are on suspension now and face the criminal charges. So we do, in fact, follow up, and we don't take these things lightly. In Princetown, similar situation. They face the courts, Central Division at Chaguanas, similar things. So it's not about incidents occurring and the police are taking a lackadaisical approach towards it. Wherever there are incidents, breaches, we take action against the officers.
Mr. Ford?
Mr. Commissioner, I just want to go back, seeing that you brought it up, the Sinclair police station. What's the status of it? You brought it up, you made a comment about, remember you, in your last report, it was up to June 2017, it was suspended, construction. But what's the latest with regards to the Sinclair police station in terms of construction? And
the government took a decision to relocate the site for the construction of Sinclair, and suspended the construction at one site and mandated that the station be constructed at another site. We have since gotten the support of the Ministry of Education, and we have housed the Sinclair police station at an old ministries building at Alexandra Street, and they have demolished the facilities which were used for Sinclair police station, and we are now in the phase of seeking to construct a new station for Sinclair.
Thanks, Madam Chair.
I want to just direct, I think everybody is all right. There's one last question I want to direct to the PCA with regards to their investigations. I'm not sure if I'm clear when I heard you say that you've handled about 800 investigations. Is that in total, or is that for the year? What period is that?
So for the year, if I could just be allowed to give you the exact figure. For the reporting period, October 2016 to September 2017, we've completed 829 investigations.
Okay. And completed means that, and all of these would have been investigations against police officers by members of the public and various persons?
Yes, yes, please, Madam Chair.
Okay. And when you say completed, means you've brought to conclusion and made a determination?
We would have either closed them, referred to the DPP, or referred to the Commissioner of Police.
Okay, all right. I just wanted to clarify.
Just one question, just for that.
Go ahead.
829 out of how many?
Out of, I'll have to get the, but some of them include, so we have a system where we deal with the backlog, and then we have matters that come up as the days go by. So the exact figure in totality, I'm going to have to add it up. We don't have that one here. The entire amount of matters that we had on the backlog system before, though, was 1,800, and now, remember that figure is also going to include all of your backlog cases, and as the months and days go by, we're going to add to it. So we've completed for the year 829.
Of those cases that have been completed, how many of them, or what percentage, let me put, have been referred to the DPP? Or do you have that at hand?
Can provide it. The figure that we have automatically coming to our minds, which is subject to correction, is 17. Referred to the DPP.
17% or 17?
No, 17.
17 out of the 800 and...
Yes, please, but I'd like to be subject to correction. We'd like to double check it and bring it back for the committee if we're allowed to do that, to double check that figure.
And that's fine, because that will give us interesting information for a report. So is it, and how many of them have been dismissed?
We would like to know that as well.
Okay. All right, and based on your investigations, though, and having concluded, there are some that you would report to the DPP, right? And then there are some that you would dismiss?
We reported, so under our remit, we can either close them if there's no evidence. If we have evidence of a criminal offense by the police officers, we're going to refer it to the DPP. If we have evidence of disciplinary, that require disciplinary action by the TTPS, we refer it to the Honorable Acting Commissioner of Police.
And in general terms, are most of the cases without evidence and therefore are closed in that way?
The short answer, the majority of cases are closed in that way. Few have been referred to, well, and I'd like the opportunity to provide the exact number, but a smaller percentage is referred to the DPP and to the Commissioner of Police.
Okay, sure. That's just general knowledge because it's not really a part of our relevant to our thing, but it was just interesting information. I would like to sincerely thank all the members of the delegations for being here, and I would like to invite them to just give us their brief closing comments, the Commissioner and the Director of the PCA, please.
Chairman and members, I indicated earlier that there are some amendments and adjustments that we would have liked to make to our previous submission. Just to indicate that our responses to question 4, 6, 15, and 20, if we can be permitted to submit some adjustments to those. And just to say that we thank the committee for accommodating us today. Trinidad and Tobago Police Service continues to commit itself to serving this nation in a professional manner. And where there are any breaches of our rules, regulations, or the substantive law, we intend to take swift action against officers. We want to give the assurance that there is no intention to breach the law in any form or fashion by the police service. And we will continue to focus on treating with detainees in a swift manner.
Thank you. Mr. West.
Madam Chair, members of the committee, we are indeed thankful for you all taking the time out and hearing what the PCA has to say on this very important subject. We are grateful for the opportunity. We are also grateful for the Commissioner for taking on the PCA's recommendation in 2011-2012 to install camera footage in the police stations. And we also have another recommendation, which is that the officers display their regimental numbers at all times, because this, and at stations, because this gives us the opportunity to identify the officer who may be in breach of some disciplinary regulation. Having said that, I would like to thank you again, and any other questions we will be happy to answer in writing back to the committee. Thank you very much.
Thank you so much. And in closing, I'd just like to summarize some of the findings and recommendations that we have discussed. All efforts are made to charge detainees promptly. However, there is no set time limit which dictates how long someone can be detained. Individuals who believe that police action is not prompt can apply to the High Court for relief. However, this is an expensive process which may be inaccessible to those without the means to do so. There are levels of supervision in the police service which are designed to reduce to its lowest level abuse by police officers with respect to unjustified detention. The PCA has 23 investigators and 8 attorneys. They require 26 investigators and 11 attorneys at least to be able to operate optimally. 2 police stations presently have accommodations for juveniles. 2 more should be added soon, which will bring the total to 4, and they are Maracas, St. Joseph, Gasparilla, who currently have accommodations, and they should soon be joined by Maraval and Belmont. Suggestions were made to introduce standards with respect to the length of time a detainee could be kept at a holding cell without charge. This may be supported by the PCA, but is not necessarily supported by the police service at this time. All efforts are made to keep cells clean and in a condition to allow all persons humane and dignified surroundings. Regular in-service training is provided for police officers, along with station-level guidance. However, there may be need for more specific and targeted interventions in some cases. Holding cells are inspected by police officers. No other authority is involved in the inspection process. This may be in contravention of Principle 29 of the Body of Principles adopted by the UN in 1998 and requires further attention to ensure compliance. Persons being detained for more than a day or 2 are facilitated with baths and change of clothes. However, the TTPS has stated that this is a rarity. All police stations are outfitted with CCTV cameras in the corridors leading to the holding cells. The holding cells themselves are not covered this way. Other jurisdictions have found solutions around this, and in Trinidad and Tobago, we may do well to consider some of these to protect both detainees as well as police officers from spurious allegations. All new station holding cells have newly designed doors to eliminate the possibility of persons harming themselves. Older stations have yet to be retrofitted to prevent these circumstances. The PCA will seek to have data readily available where issues surrounding treatment of detainees at police stations can be clearly and easily identified. Last recommendation is that the display of regimental numbers by police officers may assist in investigative processes where there are issues concerning detainees. I really want to thank everyone for being here and for their free and generous contributions to this issue, which we see as an important issue in Trinidad and Tobago, important human rights issue. And at this time, having spent a lot of your morning with us, I would like to thank our listeners, our viewers, members of the committee, and declare this meeting now adjourned.